Former President Donald Trump tonight posted a $175 million bond in his New York civil fraud case, which frees him up to start appealing the judgment. The bond halts collection of the more than $454 million that he owes, and it stops the state from seizing his assets while he appeals. The bond is essentially a placeholder that guarantees full payment if the judgment is upheld. Appellate judges last week granted the reduced bond after Trump's lawyers said he lacked cash.
Welcome back to Dr. John Podcast. So what's happening right now, Trump is drowning in a $454 million judgment that grows $87,500 every single day, with New York's Attorney General already filing claims against his most iconic properties and tracking $187 million in cash from recent real estate deals.
And this breaking news, while we were showing you that, we now have an update on former President Trump's appeal against his New York civil fraud verdict. A New York appellate judge has rejected the former president's request to put a pause on the $454 million civil fraud penalty. But the former president did win his request to temporarily delay rulings that banned him from running a business in New York State and taking out loans from New York banks. With that, we bring in Jonathan Turley.
His response to all of it isn't payment or negotiation, it's rage. The man who built his identity on being untouchably wealthy is sinking in financial quicksand, live in public. This is not speculation. This is not political theater. This is the most significant financial accountability moment in modern American political history, and it is unfolding in real time right now. Let me walk you through exactly what is happening.
Constitutional law attorney and Fox News contributor Jonathan, a bit of a split decision there for the former president. His attorneys pushed this delay on the grounds that this amount is so enormous that it is exorbitant and punitive, were their words. What do you think about this decision?
Why the financial pressure is unlike anything we have ever seen directed at a figure of this stature, and what the next steps look like as the enforcement machinery grinds closer to its most dramatic potential conclusion. The civil fraud judgment against Donald Trump started at approximately $355 million. That number alone would be staggering for almost any individual or business in the country. But that was just the beginning, because judgments do not sit still. They breathe, they grow, and this one is growing at $87,500 per day. Let me put that in perspective. Every 24 hours before any payment is made, before any appeal is resolved, before any negotiation takes place, the obligation increases by an amount equivalent to what many families earn in 2 years. That daily accrual does not pause for legal arguments. It does not stop for holidays. It does not care about public statements or media appearances. It runs like a clock, and every tick adds more weight to an already crushing burden. By the time we are having this conversation, the total has already pushed past $454 million, and it will be higher tomorrow, and higher the day after that. The compounding nature of this obligation creates a mathematical trap that anyone facing this kind of judgment would find terrifying, because the normal strategy in high-stakes litigation is to delay, wait for an appeal, hope for a reduction, run out the clock while you figure out how to pay. But when the clock itself is costing you $87,500 per day, delay becomes its own kind of catastrophe. Think about what that means for the appeal process. Let us say the appellate court eventually reduces the penalty by a significant percentage, 20%, maybe even 30%. That sounds like a victory on paper, but if the appeal takes 2 years to resolve, the daily accrual adds more than $63 million to the total obligation in the first year alone. Over 2 years, we are talking about an additional $63 million to $87,500. Actually, let me do the math correctly. $87,500 per day times 365 days equals roughly $31.9 million per year. So over 2 years, that is nearly $64 million in interest alone. A 20% reduction on the original $355 million would cut about $71 million from the principal. But if you have added $64 million in interest while waiting for that reduction, your final number is almost exactly what it would have been without the appeal. You have spent years in court, paid millions in legal fees, and ended up right back where you started. That is the trap. That is the mechanism that makes this situation different from almost any other financial enforcement case. Delay does not help. Delay makes the problem worse. Now let us talk about what New York Attorney General Letitia James has actually done, because the difference between a threat and action is paperwork, and the paperwork is already filed. James has taken the specific legal step of registering the fraud judgment in the counties where Trump owns his most valuable properties. This is not a warning. This is not a press release. This is a concrete legal action that creates what is called a judgment lien. Once that lien is recorded, it attaches directly to the properties. It encumbers their titles. It means that any attempt to sell, transfer, or refinance those assets runs headfirst into the government's claim. The properties we are talking about are not obscure commercial buildings in distant locations. We are talking about Trump Tower on Fifth Avenue. We are talking about golf courses in Westchester County. We are talking about some of the most recognizable real estate in the country. And every single one of them now carries a lien that ties directly back to the fraud judgment. Here is what that means in practical terms. If the appeal process concludes and the judgment is affirmed, the enforcement stay that is currently in place expires. The moment that happens, the Attorney General's office can request what is called a writ of execution. That writ is the document that tells law enforcement to go and physically seize assets. And because the liens are already recorded, because the properties are already identified, because the legal work of locating and encumbering the assets is already complete, the path from judgment to seizure is dramatically shorter than it would be in a typical enforcement case. James has said explicitly on the record that if Trump cannot pay or cannot post the required bond, she will ask a judge to seize his assets. That is not a hypothetical. That is a stated intention backed by completed legal steps. The only thing standing between the current situation and physical asset seizure is the bond that Trump posted to maintain the enforcement stay during the appeal and the outcome of the appeal itself. Let me bring in the cash movement findings, because this is where the story gets even more specific and even more consequential for understanding Trump's actual financial situation. State lawyers have documented that Trump took in approximately $186.8 million from two recent real estate transactions: the sale of his Washington, D.C. hotel and the sale of rights to a New York City golf course. Those are not small numbers. That is real money moving through real accounts from real deals. But here is what makes those transactions matter in the context of the fraud judgment. Part of the penalty requires Trump to hand over the proceeds from those specific transactions, plus interest. The court determined that those deals were connected to the fraudulent conduct that the civil case established. So the money from those sales is not just ordinary income that Trump can use however he wants. It is specifically identified funds that the enforcement proceedings have already flagged as subject to disgorgement. Think about what that means for the enforcement timeline. In many civil judgment cases, the creditor has to go looking for assets. They have to investigate bank accounts, track down property holdings, piece together financial movements to figure out where the money is and how to reach it. That takes time. That takes resources. That gives the debtor opportunities to move money, restructure holdings, or otherwise complicate the enforcement process. In this case, James already has the documentation. She already knows about the $186.8 million. She already has a court order saying that money is subject to the judgment. The enforcement pathway for those specific funds is already mapped out. That is not a general threat about asset seizure. That is a specific tracking of identified money that the government can move to collect the moment the legal conditions are met. And here is the broader implication. If state lawyers were able to track these specific transactions and connect them to the judgment, what else are they tracking? What other financial movements have been documented? What other transactions are sitting in the enforcement files waiting to be acted on? The fact that these specific deals have been identified and tied to the judgment tells us that the enforcement apparatus is not operating on speculation. It is operating on documented financial intelligence. Now let us step back and look at the bigger picture, because the civil fraud case is not happening in isolation. The findings that came out of that trial create a documented factual record that could attract attention from other accountability mechanisms. Judge Arthur Engoron's findings established that Trump repeatedly submitted financial statements to banks and insurance companies that significantly overstated the value of his properties. We are not talking about minor rounding errors or optimistic appraisals. We are talking about systematic inflation designed to secure more favorable loan terms and insurance rates than accurate valuations would have supported. Those findings are now part of the public record. They are documented, they are specific, and they name the properties, the transactions, and the financial institutions involved. That creates a baseline against which other financial filings can be evaluated. If similar misrepresentations appear in tax filings, the civil fraud record provides the starting point for investigators to ask hard questions. If offshore structures or shell companies were used to obscure ownership or move money in ways that did not appear on tax returns, the patterns identified in the civil case give investigators a roadmap for where to look. We have seen investigative reporting that raised questions about opaque financial arrangements, about complex intercompany transactions, about structures designed to shield assets from scrutiny. The civil fraud case does not directly address those questions, but it creates the documented context that makes those questions more urgent and more specific. And here's the thing about financial accountability. It tends to snowball. One enforcement action creates documents that create leads, that create new investigations. The IRS does not need to start from scratch when a state attorney general has already done the work of documenting financial misrepresentations. The information flows, the scrutiny compounds, and a defendant who is already facing a $454 million judgment with daily interest does not need additional investigations adding pressure to an already explosive situation. Now let me talk about the response, because the way Trump has reacted to every step of this process tells us more about what is actually happening than any financial filing could. When the civil fraud trial began, the attacks started. When the judgment came down, the attacks escalated. When James registered the liens, the attacks became more personal, more aggressive, more focused on the individuals involved rather than the legal arguments. The judge was labeled corrupt. The attorney general was labeled a political operative. The entire enforcement apparatus was characterized as weaponized government being deployed against a political opponent. These are not legal arguments. They are not defenses on the merits. They are attacks on the legitimacy of the institutions that are holding Trump accountable. Here is what behavioral analysis tells us about that pattern. When someone who has spent decades building a public image of invincibility suddenly finds themselves facing consequences they cannot avoid, the psychological response is often to attack the source of the consequences rather than address the underlying problem. You cannot pay the judgment? Attack the judge. You cannot stop the liens? Attack the attorney general. You cannot make the daily interest stop compounding? Attack the system. But attacks do not stop interest from accruing. Attacks do not remove liens from properties. Attacks do not make documented financial transactions disappear from court files. And the escalation of those attacks tracks directly with the escalation of the enforcement proceedings. The louder the screams, the closer the consequences. We have seen this pattern before. Every time an accountability mechanism gets close enough to actually affect Trump's assets, the rhetoric intensifies. The threats become more dire. The accusations become more extreme. It is the behavioral signature of someone who understands exactly how serious the situation is and has run out of conventional options for dealing with it. So where does this go from here? Let me give you the specific things to watch, because the outcome of this situation will be determined by a handful of key developments that we can track in real time. First, watch the appellate resolution. The court will eventually rule on the excessive fines challenge and the other arguments Trump has raised. That ruling will determine the final dollar amount that he actually owes. But remember, the timing matters as much as the number. Every day that passes before that ruling adds another $87,500 to the obligation. A favorable ruling that comes too late could still leave Trump facing a number that is functionally equivalent to the original judgment because of the accumulated interest. Second, watch the bond situation. The current bond of $175 million is what maintains the enforcement stay during the appeal. If that bond is found to be insufficient, if there are questions about the collateral backing it, if the court determines that the bond does not adequately protect the state's interest, the stay could be lifted before the appeal is resolved. That would accelerate the timeline dramatically and bring physical seizure that much closer. Third, watch for additional asset identification. If James files more liens, if she registers the judgment in additional counties, if she documents more transactions and ties them to the disgorgement requirements, that builds the enforcement picture and narrows the gap between where we are and where the writ of execution becomes the next logical step. Fourth, watch the broader financial scrutiny, the IRS dimension, the offshore structure questions, the shell company concerns. These are not the primary story right now, but they are are the background pressure that could turn a difficult financial situation into an impossible one. If federal investigators start following the leads that the civil fraud case has already documented, the accountability picture expands dramatically. Let me bring this all the way home with the 4 points that matter most for understanding where we actually stand. The $7,500 per day interest accrual is the most powerful financial pressure mechanism in this entire situation because it makes delay a losing strategy. Normally, wealthy defendants use appeals and legal maneuvering to buy time. Here, time costs $31.9 million per year. Every month of delay adds more than $2.6 million to the obligation. Every week adds more than $600,000. The trap is built into the math, and there is no legal argument that can make the interest stop running. The judgment registration in counties where Trump owns his most iconic properties is not a future threat. It is a completed legal action that has already encumbered specific named assets. The liens are recorded. The properties are identified. The path from where we are to physical seizure is procedural now, not investigative. The only remaining questions are timing and appellate outcome, not whether the assets can be reached. The $186.8 million in documented recent transactions is the specific evidence that ties Trump's actual financial activities directly to the judgment enforcement proceedings. This is not general background information about his wealth. It is identified money that the court has already said is subject to collection. The enforcement apparatus is not searching for assets. It has already found them and documented them in the court record. And the escalating attacks on everyone involved in the enforcement process tell us exactly how serious the situation is. People who are confident in their ability to pay do not spend their time screaming about the people asking for payment. People who have legitimate legal arguments do not spend their time attacking the legitimacy of the courts. The intensity of the response is a measure of the intensity of the pressure. Here is what we are actually watching. The most financially consequential accountability moment in modern American political history is unfolding in real time. A $454 million judgment growing by the day. A state attorney general who has already taken the legal steps necessary to seize assets. Documented cash movements totaling nearly $187 million that have already been tied to the enforcement proceedings. An appellate process where delay makes the outcome worse rather than better. And a defendant whose response to every new development is not payment, not negotiation, not legal argument, but screaming attacks on the institutions and individuals holding him accountable. The financial pressure is real. The enforcement steps are documented. The timeline is accelerating, and the outcome, whether it is payment, seizure, or some combination of both, will tell us something fundamental about whether the most powerful figures in the country are ultimately subject to the same laws as everyone else. We are going to be right here covering every development as it unfolds. The appellate rulings, the enforcement steps, the financial disclosures, all of it, because this story is not going away. It is getting bigger every single day.